State for the Home Department.
Mr. Saini.
Hello, ladies. In this appeal, I appear with Professor Tridimas and Mr. Binsky on behalf of the appellant. My name is Solicitor Ward, Queen's Counsel, and Mr. Alban appear on behalf of the Secretary of State. Before I begin, can I just check if the court has received two further bits of material? One is a note on supplementary authorities, and secondly, a note on the facts. Those were submitted by us last week.
Yes.
I'm obliged. In addition to that, there should be on the tables before you a short further bundle of authorities from my friend Mr. Ward. He's going to introduce those when he makes submissions this afternoon, but I just wanted to check you've got those.
What was the first one?
I'm not. There's two notes. One is entitled Note Appellant's Note accompanying supplementary authorities.
Oh, yes, I do. Thank you.
And the second note is called Note 2 concerning statutory and factual context.
Well, I don't think I've pointed those in. Has anybody got a spare copy of those?
I think we can certainly provide those, my lord.
Thank you very much.
Thank you very much.
The reason we put those in is because there's a lot of material to cover in a day and a half, and I'm going to do my best to not go beyond my 2.5 hours this afternoon. With that introduction, can I indicate that I'm going to divide my...
Well, if you do go beyond your 2.5 hours, it will eat into your reply.
Absolutely. I'm going to do my best to stick to the time that I've agreed with Mr. Ward. I'm going to divide my submissions into 6 parts as follows.
Right.
First, I want to introduce the case by reference to 2 themes which will appear and reappear. That's the right to liberty and the right to free movement. Secondly, I want to identify and summarise the relevant UK and EU legislation. Thirdly, I want to address the court on why the legislation in issue falls to be struck down under general common law, EU law, and ECHR principles of equality. Now, by equality, I use that term generally to mean all principles of non-discrimination and equal protection. Fourthly, I will address proportionality. Fifth, the principle of legal certainty. And then finally, sixthly, I'll address the freestanding transposition complaint, where the court will have identified that there is an issue as to whether or not, irrespective of our other arguments, there has been a correct transposition of the Citizens' Directive in the relevant regulation. Now, if I can go first then to my introduction and the twin themes in the appeal, liberty and free movement. The principal issue in this appeal concerns the legality both at common law and under EU and convention law of a provision in secondary legislation made under Section 2.2 of the European Communities Act 1972. I emphasise that point at the outset because we have a rather novel provision here in this respect, which is that the government took the decision using secondary legislation to create a wholly new and novel power of executive detention. It's not suggested by the government that anything in EU law required that power of detention to be created. So basically, the government decided in 2009 to create this new power to detain people while the Secretary of State was making her mind up as to whether or not to deport them, albeit they are EU nationals.
But you're not suggesting that it was ultra vires, Section 2, subsection 2?
Well, I do have a general ultra vires complaint, which is that I'm not saying that it was out. If otherwise, this legislation survived the attacks I make, I wouldn't be having a freestanding argument, as I know there's a recent case of this court concerning Section 2.2. I'm not running the argument that somehow Section 2.2 did not authorise this by reference to the
Right, that's all I was checking.
Absolutely.
I mean, given the number of arguments you are running,
yes.
I just thought I'd better make sure
Yes,
there's nothing
that's
else.
one I'm not running. That's one I'm not running. But I do emphasise the point that it was made under Section 2.2, and therefore one doesn't have the position that one had in the Belmarsh cases, where the court was being asked, in that case under the Human Rights Act, to make a declaration of incompatibility in relation to primary legislation.
Okay.
So we have a secondary form of legislation.
Okay.
Now, the specific power is in Regulation 24.3, and it will not surprise the court that my starting point is going to be the right of liberty. And again, it will not surprise the court in the 800th year anniversary of Magna Carta that I'm going to rely upon Chapter 39 of the Charter, and in its various versions, essentially the common provision is that nobody can be imprisoned, outlawed, or banished except by the lawful judgment of his equals or by the law of the land. Now, by the law of the land, what's absolutely clear is meant by that is not just simply that the court looks to the statute book and says, is this detention authorised by the law of the land? The common law has always conducted a much more exacting inquiry. The common law, when it looks to the law of land, needs to be satisfied that the relevant law that's relied upon meets basic standards of the rule of law. And in this case, those standards include the principle of equal protection of the law or non-discrimination, and also the principle of legal certainty. I emphasise at the outset that the common law requires, in some respects, much more, and certainly no less, than EU law or convention law in terms of scrutiny of legislation which enables executive detention.
But the common law doesn't give us any power to strike it down.
Well, indeed it does, lady, because I come back to the point, this is delegated legislation.
Secondary legislation.
Absolutely.
Fundamental point. Yeah.
Absolutely. And therefore, we have the, in some ways, happy position where the court doesn't have to deal with this question of whether or not there are some entrenched constitutional rights which prevent the court, which would allow the court to interfere with primary legislation. We have secondary legislation here. And it's not in dispute between Mr. Ward and myself, and there's a clear case, Jarvid, which we've cited, which makes it clear that on conventional judicial review principles, the court has the ability, and in that has regularly struck down secondary legislation. So we don't have that problem. So therefore, this court has all of the tools, as a matter of common law, to strike down the legislation. So that's the common law position. That's the first theme, liberty. And
where does Magna Carta come in your case?
well, I've certainly mentioned we have a part of our case which refers to the principle of equality being exactly the same.
I understand
Absolutely.
that, but the whole idea that we're in sort of Magna Carta territory was a new one on me.
Well, Lord, we've certainly made clear that the principle of common law respects the principle of liberty. If you ask me, where does that come from, if one needed to ask that question?
No, I'm just trying to get to grips with your case, as you admitted outside.
Other new points,
it changes. One of them, you made many new points which weren't taken below, and we're trying to struggle with them. At some point, anyway, I, for my part, would like on 1 or 2 pages a summary of the points which still are in play, and
Certainly
not.
Certainly, my lord.
So are you really saying that Magna Carta undergirds the points which you are making?
Absolutely, absolutely. No more than that. And it is one of the provisions that appears on the statute book still.
I know that.
But
It's just a question of which ones. There are lots of things on the statute book which I think are not reliable.
absolutely, absolutely. But sorry, just finishing there. The case was not argued at common law below.
I understand, but it is now.
But it is now,
Okay.
and it's argued at common law based on the principles of the rule of law, which require respect for the principle of liberty.
Yeah.
And what I'm going to take you through, what one might regard as convention law or EU law principles, or for example, legal certainty, or non-discrimination, I will also remind the court, and this is in our case, that one can find exactly the same principle in cases within this jurisdiction. So, oddly enough, one starts this case with common law, and if one needs it, if there was a dispute, one can go to EU law. But in no respect in this particular case can one say that, as far as liberty is concerned, the common law is less exacting than EU or convention law. That's the first theme. Second theme, which is not a common law theme, but underlines this case, is the principle of free movement.
Yes.
And it's common ground between myself and Mr. Ward that my client enjoys free movement rights. And indeed, the legislation we attack applies not just to third country nationals, such as my client, who have EU law rights, but applies generally to any EU national.
Yes.
So throughout this case, I'm going to refer to EU nationals
Yes.
as covered by the relevant legislation.
So
And
the free movement argument is an EU argument,
Absolutely.
not a common law argument.
That's
Okay.
absolutely right, my lord. And again, it's common ground that the effect of Regulation 24 is to interfere
Yep.
with the free movement right. And again, it's common ground that that legislation then needs to pass muster under 3 principles: equality, proportionality, and legal certainty.
Yes.
But again, as I've said, one sees those principles also in common law. So although there is an overlap between the right to liberty and the free movement arguments, it's important to keep them separate, because if my friend persuades this court that we are somehow arguing a case under EU law on the boundaries of EU law, or there's some development we're seeking, then it would be appropriate to make a reference. But that's very much a secondary position. We say we can win this case at common law.
If you lose at common law, does it follow you must lose on EU law?
No, my lord, because we have a separate right under free movement principle.
I know you have a separate right, but since in each case it's being restricted, what are the differences in the arguments?
Well, the argument could be if my friend succeeds in persuading you that the common law standards, in terms of, for example, justification, are less exacting.
Well, you say they're more exact.
I say that they're certainly no less than.
Well, then the two should go together.
Yes.
Shouldn't they? On your case.
They should in principle go together, but there is a possibility that the court may come to a view that they don't have the same.
But on your
same
case,
coverage.
they go together because.
Absolutely.
Okay, thank you.
So that's the two themes I want to underline: liberty, respected at common law, and secondly, free movement. And I want to turn now to the legislation, and I want to take this quite slowly because there's a lot of legislation, and in addition, the amendments and when they were made is very important in this case.
Thank you.
And as I said a few moments ago,
So is there a good chronology of showing all that?
we have actually provided it in our additional note, in one of the notes that I mentioned this morning, which is a note on the statutory
So
background.
while we're going through the legislation, it would help if we went
Indeed.
through that.
But I'm going to start with, we've done a chronology of the development of this legislation at the back of that note. But
Note 2 or the other one?
I believe it's the
I think it's note 2.
note 2.
Yep, thank you.
And
Next 2 to note 2.
absolutely. Can I start with
Yep.
a proposition which is not in dispute, that the first legislation that concerned detention of
Yes.
EU nationals prior to deportation
Yes.
was not until the year 2000.
Yep.
Prior to that, so for the whole of the period from 1973 until 2009, the position concerning the detention of an EU national prior to deportation was governed by the 1971 Act. Now, while one has that note open, could I ask the court please to take up Authorities Bundle Volume 1? And if the court could please go to Divider 1, which contains the 1971 Immigration Act.
Yes.
And have you a electronic bundle number for that?
552. Yep.
And I'm going to take you, please, to page, it's Schedule 3 and Electronic Bundle MS page number 605.
Thank you.
Yep. Yep.
And if I could ask the court to please go to Schedule 3.
Yes.
Bottom of the page, you'll see a heading right at the bottom, detention or control pending deportation.
Yes.
And if one goes over the page,
Yes.
and then if one can go to see paragraph 3, please, which begins where a deportation order is in force.
Yes. Some paragraph.
That's right.
It's 2 subparagraph.
2, 3.
That's right.
Yes.
That's quite right. So essentially, when a deportation order was in force against a person, he could be detained under the authority of the Secretary of State pending his removal. Now, that's effectively the default position that applies to all deportees, whether you're an EU national or a true third country national. That was applied to EU nationals. And
What about subparagraph 2? Detention pending the making of a deportation order.
After a decision. Sorry. So after a decision has been made.
that's after a decision has been made. So
Yeah, but before the
prior to a
actual
decision.
order has been made.
absolutely.
Yeah.
And then if you can stay, please stay in this bundle, and please go to divider 5 in this bundle.
Yes.
And this is the immediate predecessor legislation of the legislation that we're dealing with. And these are the Immigration EA Regulations 2000.
Yes.
And if you can please go to page 630.
Yes.
And if you could read paragraph 26, please, 26.3.
26.3, right?
That's right. And in fact begins at 21, that to give it some context. So the broad provision at 21 at 629 is, this concerns EEA nationals. 21.1 and 21.2, that's people being admitted. And 21.3b, over the top of the next page, explained that an EEA national or a family member could be excluded on grounds of public policy, public security, public health.
Yeah.
And then if you just go down the page to 26.3, that type of person, in other words, a subparagraph 321.3 person,
Yes.
could be detained pursuant to the power which I've just shown you in the 1971 Act.
Right.
Now that's quite important, because what Parliament was doing there was creating a statutory analogue. It was saying in 2000 that these people who can be removed are EEA nationals, we're going to treat them in the same way as those who are being removed as third country nationals. A statutory analogue, that's very important, because it's going to the question of
Now, this
comparators.
is EA, is it, or EC?
EEA.
Not EC.
Well, I think the EEA includes EC. It's a wide.
I'd like to know when where, if ever, there is a distinction between EC and EEA.
Within these regulations, it's perhaps I can just.
Because the cases are very obscure about that, I think.
Okay. I'm told that it's dealt with in footnote 1 of our printed case
And what's the answer?
at page 2. The relevant regulations we're dealing with here apply to all EEA nationals, which includes EC nationals, EU nationals, sorry.
So the Citizens Directive is expressed as applying to EU nationals.
So this applies to all EU nationals,
Correct.
Other than the host state.
other than the host.
Correct. Absolutely. Absolutely. Now, the reason I showed you these 2000 regulations.
Perhaps you'd be kind enough as you go along to draw any distinction there actually is, if any, between EEA on the one hand and EC on the other.
But the reason for showing you these 2000 regulations is that there was what I call a statutory analogue created, which is there was no need to apply any other regime. Then what happens next, just picking up the chronology, is that if one goes to the 2006 regulations as they were originally made, and it's quite important here to, this is summarised in our supplemental note, but if you have the Supplemental Authorities bundle, volume 15,
Yes.
if I could direct you to that, and to page tab 175, which is the very first tab, page Sup MS page number 3, which is where they begin, the electronic bundle. And within that,
Yes.
I don't think we've got the supplementary bundle electronically loaded.
not,
It should have been sent.
I'm sorry, it should have been sent, but it may not have been uploaded. It certainly was. I certainly received it in an electronic form as well. But
Did you get two? You know, the main one and then the supplementary one.
yes, I thought I certainly have seen it, have it in electronic form. But perhaps I can provide a hard copy of the supplementary bundle.
No doubt we've got it here.
Okay.
We've got the hard copy.
Yeah. So it's it's the first tab 175. Now, these 2006 regulations, this was the United Kingdom's implementation of the Citizens Directive, which we're going to come and look at in a moment.
Now, this is what in your Annex 2.
That's right.
So we can look at Annex 2 from now.
Absolutely. Yeah. And what's important to note at page 11 of this of these regulations is we have a provision at paragraph 19, which again essentially replicates the provisions for removing people.
Yes.
But as regards detention, if I could ask you to go to paragraph 24, regulation 24 at page 14,
Yes.
The statutory analogue continued in 2006,
Yes.
by which I mean that the government had decided at this point in time they were going to carry on the position as it had been since 1973, as exemplified in the 2000 regulations, which is that the only persons who could be detained were those against whom a deportation order or decision had been made. And there was a reference back in 24(3) to those powers in the 1971 Act which enabled detention. So again, the statutory analogue is continued.
Okay. Yep.
But then there was an unexplained, and I'll come back and elaborate on that in a moment, a change, a fundamental change
Yes.
in 2009.
Yep.
And in the Authorities Volume 1,
Now, this is all in your annex, isn't it? Can we not just work on... The whole point of having an annex is to be able to follow it and not have to fish about the authority.
it's at page 8 of the, sorry, paragraph 8, page 16 of the annex. But I want to show you the particular piece of delegated legislation
Tab.
that achieved this change,
Yes, which tab? Or
which
page?
is in
Which page?
Authorities Volume 1,
Yes, which tab, which page?
and tab 10,
Thank you. Page? 707.
MS page number 707.
Yeah.
Now, as the court will see, these regulations were made under Section 2.2
Yes.
of the European Communities Act. And then if one goes, please, to page 710, MS page number 710,
Yeah.
paragraph 10, middle of the page, a new Regulation 24. And you will see new Regulation 24 says in subparagraph 1, if there are reasonable grounds for suspecting that a person is someone who may be removed from the United Kingdom under Regulation 1913, that person may be detained under the authority of an immigration officer.
Which page is this? Sorry.
I'm sorry, it's page 710.
710.
Okay.
And on our note, it's on paragraph 8, page
I see.
16.
Yep.
So this is a wholly new power created by secondary legislation
Yes.
to detain somebody if there are reasonable grounds for suspecting that there's somebody who may be removed under Regulation 19.3.
Yes.
So what hitherto had been the application by way of a statutory analogue to those persons under the 1971 Act was fundamentally changed.
Okay.
And I say it's unexplained because there was nothing in the explanatory notes
Right.
to explain why this has been done.
Right.
And there's no evidence from the Secretary of State explaining why this has been done. So we have the position which both courts below accepted, which is that a person in my client's position, or EA national, is in a different position to someone who is a pure third country national. A pure third country national, in the same position as my client, cannot be detained unless and until a deportation order or decision has been made against him.
Yes.
Yet someone in the position of an EA national, who one might think would have better rights, can now be detained while the Secretary of State makes her mind up
Yeah.
on the basis of reasonable grounds for suspecting.
Okay.
So one has immediately there a difference in treatment, and we'll come to look at why we say that is unlawful. There's an immediate difference in treatment.
Sorry, can I just be clear? You say there's not in the explanatory notes. There's no reference to this
What?
at all.
There's certainly, if one looks at, we have the explanatory notes actually in this same.
712N.
That's
But
right.
There's no reference to paragraph 10, you say?
That's right. I'm not aware, but my friend will correct me if I'm wrong. I'm not aware of any
No, I can't
any
find
reference
that,
to this
so-
because one might expect
Okay. Well, you say there's no explanation.
no evidence.
And there's been no, all the time this has been trundling through the courts, no explanation has been given of this.
No. What one might have expected.
Or requested?
Well, we made the point in our case some months ago now, which is that the Secretary of State's position, which is a defensible position, but we think ultimately wrong, is that they don't need to provide any additional evidence. They're just willing to argue the case on the basis of non-discrimination principles. What they haven't done, this is not a criticism, it's just the way the case is, they haven't done what was, for example, done in the Belmarsh case, where the Secretary of State submitted evidence explaining, well, foreign national prisoners who we can't deport, there are these particular factual reasons why they are detained. By contrast, UK national prisoners, they're in a factually different position. And there was quite detailed evidence examined in particular by Lord Bingham in that case.
Yeah, no, it's more that just where there's a change of approach
Yes.
in legislation, one quite often expects to see someone saying why it's been done.
Well, we've certainly done very thorough research on this,
Okay.
and we haven't been able to find it. And my friend hasn't, in his case or in his authorities, come up with any articulation as to why this change was made.
Very well.
So that's where we are now. Can I, while I'm in the legislation, go to the legislation as it currently stands, which is in this same authorities bundle 1.
Is that in your note?
It is.
Or maybe we could have it in the note. I mean, there's not much point in having a note, then disregarding it.
Okay. Well, perhaps I could, by way of slight defence, can I just say that the points that we make in the note are to give a complete record to the court, because we didn't agree with Mr. Ward's summary
You've
of
got
the
a
position.
complete record, then it'll be in the note.
Absolutely.
Where is it in the note?
But can I take you to, I just want to show you some parts of the legislation which arise later on as relevant, but so I don't have to go back to it. I just want the court to bear in mind certain provisions back in Authorities Volume 1. And
We're looking at this because
I want to show you that not only is there no explanation as to why in 2009 there was this radical...
We got that.
Yeah, but also to make the point that whoever went about making the amendments in 2009 didn't realise that they had to provide some procedures or principles in the legislation they were amending to indicate how the Secretary of State or her officers were meant to go about deciding
Right.
who to detain and when.
Right.
So if one can go to the legislation that's at tab 9 of this bundle, which is, if I'm be correct if I'm wrong, the current version. So this is the legislation as it is today. And I just want to identify as they go along certain points. If you'd please look at the general interpretation on MS
Now,
page.
do I understand that these repeal the 2000 regulation?
Correct.
Thank
Correct.
you.
They entirely replace the 2000
Okay,
regulations.
Thank you.
So if one can go please to MS page number 672, which is the start. Bottom of the page one has general interpretation. We have the 1971 Act referred to then over the page at MS page number 673.
Yes.
And if I could ask you to go down the page and note in the middle of the page the definition EA decision.
Yes.
Means a decision under these regulations that concerns a person's entitlement to be admitted to the United Kingdom.
It's C.
It's C, person's removal. What one does not see here is any definition of an EA decision, which includes a decision as to whether or not to detain them pending a decision on removal, which is quite an important point. And then if I could ask you please to go to, in this document, to MS page number 694, bottom of the page, you will see at paragraph 21 a heading, decisions taken on public policy, public security, and public health grounds. And then over the page, please, to MS page number 695.
Yep.
And then once it's at the top of the page, in this regulation, a relevant decision means an EA decision taken on grounds of public policy, public security, or public health. And then one has certain criteria set out there.
Just going back for one moment, the definition of EAA decision sets out 4 very broad topics: entitlement to admission, entitlement to issue with appropriate card, removal, and cancellation.
That's right.
Those are the areas which fall within an EEA decision. Might one not say that a decision to detain as part of the process towards removal based on an estimation that that is something which is likely to happen, falls within that broader ambit.
Well, one could argue that, my lord, but then one looks to the regulations to see which particular principles is one going to apply when making that decision. So, for example, if one goes to the regulation 21, which I was taking the court to, which is starts at the bottom of 694 but continues over the next page, and one has here the factors to be taken account in making a relevant decision, which is a decision on grounds of public security, public policy and public health. One doesn't see here a distinction between which criteria apply to detention decisions and which criteria apply to expulsion decisions. Now, I'm going to explain why that's relevant in a moment, my lord, when we get to the Citizens Directive, and particular Articles 27 and 28, which the court may have looked at in its pre-reading. But one is left at a loss to try and work out what are the criteria to be applied when a detention decision is being made. And this goes back to my point, which is whoever introduced...
Wait a minute, are you saying that a detention decision isn't incorporated in this, despite what the argument which Lord Toulson put to you? Are you saying it is, but it's unclear which of these principles apply, or are those your two alternative arguments on this?
Well, if the Secretary of State's position is that all of the requirements that are set out in 21 apply to detention decisions as well, as a matter of construction, we'd accept that. So if every one of those requirements were going to apply, we'd accept that.
Right.
In other words, all of those safeguards.
Yeah, we understand. Yeah.
But one doesn't see that set out there. But if that's the way that the Secretary of State says that this is to be read compatibly with the Citizens Directive, which we've got to look at yet, in other words, and I emphasise this point, all of the safeguards in Articles 27 and 28 apply to deciding whether to detain, and that's a way of reading this particular regulation compatibly.
Yes.
But at the moment,
so if that's right, where does that take you?
well, that still doesn't. That deals with, in a sense, the end of our submissions, which is the transposition points. It's not going to be a knockout blow as far as our other submissions are concerned. All I'm explaining at the moment, my lord, is that whoever drafted this, particularly whoever put in the 2009 regulation, which created this new power of statutory detention, they never thought about it. They really should have set out in some provision in these regulations what is the decision-making process going to be for the Secretary of State when she exercises this new power? Is she going to be applying all of the safeguards in Regulation 21 or not? Because on its face...
But I mean, surely one's got to bear in mind that one's talking about suspicion rather than decision, as a sense. But given that, one would assume one would take into account these factors, because why not?
Well, I think it's because, we'll look at this in a moment, the Article 27 and 28 factors don't overlap completely.
But just to pursue Lord Carmar's question a moment, if you go to 24.1, keeping one's finger also on 21, 24.1, under which the detention was carried out, requires there to be reasonable grounds for suspecting that that a person is someone who may be removed, and under the earlier provisions. Now, they can, in determining whether they are to be removed, Section 21 bites, and therefore in considering whether they are suspecting there's somebody who can be removed, Secretary of State's got to consider, has she not, whether they may be removed under the regime as it is, incorporating 21.
But 21, my lord, imposes, and I think this is common ground, exacting standards where the Secretary of State has to come to a conclusion, a final conclusion, and the cases make it clear it's really very difficult to deport someone using those powers of public policy, public security. But
the question at 24 is whether there's reasonable ground for suspecting that they may fall within that ambit, isn't it?
But then the question is, how does one go about doing that? And is one applying Article 27 or Article 28 of the Citizens Directive? That's why I really, to make this submission good, I need to take you to those provisions
Very well.
to explain where the problem is lying. But so
Yes? So where do we go to?
So
do we
if
go
one
there
can-
now, or do we...
So I made the point that we need a concluded decision under Regulation 21, because Regulation 21 appears to apply to concluded decisions. But then one goes to the question of what are the particular safeguards to be applied when one comes to deciding whether or not to expel or detain. So in that regard, one needs to go to the Citizens Directive,
Yeah.
which in this tab 17 of this same bundle,
Thank you. Yep.
and I'm not going to go through all of the recitals which we've set out at some length in our case, but if I could ask you to please turn to Articles 27 and 28,
Yes.
which are at MS page number 782.
Thank you. Yep.
And the stringent requirements, they form two parts. First, under Article 27, we have general principles, and it's common ground that my client benefits from this directive, as would all EA nationals.
Yeah.
One sees at subparagraph 2, measures taken on grounds of public policy or public security shall comply with the principle of proportionality and should be based exclusively on the personal conduct of the individual concerned. Previous criminal convictions shall not in themselves constitute grounds for taking such measures. And then one sees the very high test at the third main paragraph, just above paragraph 3. The personal conduct of the individual concerned must represent a genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society.
Yeah.
And then, so that's the general principle, but then one has a lex specialis at Article 28 dealing with expulsion. So 27 concerns any restriction on free movement, and then at 28 we have protection against expulsion. And then one has various safeguards set out there. And in particular, you look at over the page at page 783 at the top.
Yep.
Now, the question arises going back to my Lord Toulson's question about Regulation 21. Which provisions are they saying, this is the Secretary of State, apply when the Secretary of State is making her decision on detention? Bearing in mind, I emphasise this point, no concluded decision would have been made by the Secretary of State on these very serious grounds. There is silence in the regulations as to which of these requirements are applied. Now, if it said that, well, the way that one practically deals with these regulations in the detention context is that applying Regulation 24,
Yes.
one asks, has the Secretary of State got reasonable grounds for suspecting she might be able to satisfy one of these serious grounds?
Yes.
That's what might be said. But which grounds? Is it all of Article 27 and all of Article 28?
Well, surely, when you make a decision to deport, you have to have one or more of those grounds,
Yes.
and you have to take into account certain principles. And if you're invoking Regulation 24 as substituted by the 2009 regulations, you have to have reasonable grounds for suspecting that a decision based on one or more of those grounds will be satisfied.
Except, if one goes back to Regulation 21,
Yes.
So I'm just going to... which is the provision which deals with decisions taken on public policy, public and public health grounds. That regulation, Regulation 21, it conflates Articles 27 and 28 together, puts them together.
But yes, but it may be that whether that's right or not, you're still asking a slightly different question under Regulation 24. You're not deporting somebody at the stage of 24, you're doing just the opposite, you're keeping them here.
But the simple point is that reasonable grounds
Yes.
is such a low test. We say that can't justify a detention decision consistently with Article 27 of the Citizens Directive. It's an exacting test.
But what is, I mean, I can understand your point, that there seems to be a different structure in the regulations
Yes.
to the directive, and that means we're sort of playing around a bit. But there's nothing, assume you've got to exercise your detention decision compatibly with Article 27, 1 and 2. What's the problem with that?
Well, if the Secretary of State accepts, and we made this point in our case, and this is a completely separate point to all of our other challenges. If the Secretary of State accepts that all of the safeguards in Articles 27 and 28 are to apply.
27, not 20, 28 is expulsion.
Yes.
So you've got to have reasonable grounds that you're going to get to the Article 28 position.
Yes.
But while you're detaining, all you've got to do is to make sure you comply with the general principles, which is 1 and 2 and 3. But
Article 27 itself requires a concluded decision.
well, I don't know what you mean by a concluded decision. It requires you to take account of these things and to comply with what it says.
The only concluded decision you need is that there are reasonable grounds for suspecting, etc.
Yes, I mean, that's a decision, but it's...
Mr. Annie, I'm a little concerned on your behalf. You're a third of the way through your allotted time.
Well, I'll come back
At the moment, we're going in a considerable degree of detail into point 2 of your 6 points, which you've actually already covered in writing in your note.
What I'll do is
I'm
perhaps
concerned that you're actually cutting into the time that you may want to spend on the principal matters which follow. It might be a better use of your time if you are able to make your points on the legislation by way of a sort of succinct summary, cross-reference to your note, rather than pursuing the present exercise.
I'm very grateful. That's what I intend to do. And in a sense, it's the very last, it was the 6th point of my submissions, but I've been slightly sidetracked. If I can go back to just showing you 2 other pieces of legislation in this authorities bundle, which are going to be relevant to the submissions in relation to equality and discrimination. Now, if I can first of all show you a divider 15, please, which is MS page 737.
Yep, Charter Fundamental Rights.
Charter. Again, the court will have picked it up.
Where do you want us to look?
Just a note, page 739, Article 6, right to liberty. Oh. Okay, my friend tells me that the correct version of the Charter is in the supplementary authorities bundle.
Right.
184. But,
Anyway, we got the right to liberty.
okay, if I can just identify the articles. Article 6, right to liberty.
Yep.
Article 20, equality before the law. Everyone is equal before the law.
Yep.
Article 45, free movement.
Well, unfortunately, we don't have Article 20 in the version that we would take. But we do have that.
Okay, and crucially, Article 21, which is non-discrimination, which has 2 limbs.
Yes.
One is a wider anti-discrimination guarantee, 21.1, and then 21.2, a nationality-based discrimination provision.
Yes.
And just for completeness, staying in this bundle, we have the TFEU, which is the Treaty on the Functioning of the European Union, at divider 13.
Yes.
Where Article 8 of that?
Yeah.
So sorry, it's a divider 14. Treaty freedom of functioning of the European Union, and there's Article 18, which is MS page number 732. Again, you'll be familiar with that provision of Article 18.
Well, yes.
Now, that being the background to the legislation, in the interests of time, as I've said a moment ago, I'm not going to go through the recitals to the Citizens Directive, but I hope the Court takes it from me that the purpose of the Citizens Directive was to strengthen the rights of free movement and to specify in some detail the procedural restrictions on interferences with that right. And I'm going to now then deal straight away with the principles of equality and non-discrimination. And I'm going to pick it up by taking you first, please, to a case, which is the Glatzel case, which is in volume 11, tab 136.
Yep. Page.
At page, MS page number 4041.
Thank you.
And just by way of background, this was a case concerning disability discrimination alleged against an individual who'd been refused a driving licence on grounds of visual disabilities. That's the very broad back. It doesn't really matter for the purposes of what I'm going to show you. If you please go to the top of the page. In fact, I could ask you to go to the left-hand side first to pick it up at 4040. And it's 41 and 42, if the Court could read that to themselves, particularly 42.
What, at the bottom of the page?
That's right.
Okay.
And then the top of the page, 43, and this is a general principle. This is divorced of any specific directive or regulation. The principle of equal treatment is a general principle of EU law enshrined in Article 20 of the Charter, that's the equality provision I showed you a moment ago, of which the principle of non-discrimination laid down in Article 21(1) of the Charter is a particular expression. And the Court carries on. So there is a long line of case law, which we've set out in our written case, where the Court has held that the principle of equality and the principle of non-discrimination has been violated in cases where the particular facts and matters don't seem to fall within a specific directive. Now, our submission is that principle of EU law that one sees there, is effectively the same as the principle which is now part of modern public law, the principle of equality and non-discrimination. And in our written case, we've set out at page 21, paragraph 59,
Written case.
written case, paragraph 59. It's in the PDF version. It's MS page number 84.
Thank you. Yeah.
Sorry, which paragraph
I'm
number?
sorry, it's page 59, and it carries on.
Paragraph
page,
59.
Sorry, I'm so sorry. It's paragraph 59.
Page 84.
That's right, and it carries on to 63. And underline the submission that there's no difference of principle in a common law challenge based upon this principle of equality or non-discrimination and what the EU says is a general principle of non-discrimination.
There's no case that says that, is there?
No, and it may be it's effectively time for the Court to accept that. One can see...
Well, we don't need to for this.
We don't need to, but one can see in particular in Lord Sumption's judgment in the Bank Mellat case, which you cited, he refers back to. We've cited it here.
But I mean, why do we need this? I mean, you know, the question of equality as a judicial review principle has been knocking around ever since Matterdine and so on, but you don't need it.
Well, it's I only make the point for this purpose, which is my original submission was that we don't need any, it don't need to rely upon EU law or convention law. And it is a principle of rational behaviour that public authorities abide by this equal treatment principle. That's the only reason I'm showing you that. And I showed you the EU law case to say that it effectively reflects the position public law in this country has already reached. Now, that's the freestanding principle at common law. and as a matter of EU law. But there is a more specific principle that applies, and one can perhaps put this case, staying in this bundle, volume 3. If one could please go to divider 134.
Yes.
I'm sorry, it's volume 11, and it's MS page number 3967, which is
the famous Ackerberg-Franzen.
Ackerberg case,
Yeah.
which is a case about tax law and whether there was a double penalisation contrary to EU law. But what's important here is page 3972, paragraph 16
Yes.
to 22, and in particular, it's 20 to 22.
Yep.
And it's the concept of the field of application. That's the field of application of the Charter.
Yes.
And the Charter applies, and I believe this is common ground, as soon as a member state starts to implement EU law. And we know that the regulations that are challenged in this case are a UK government implementation of EU law, and therefore the Charter applies. Now, why that's important is that if the Charter applies, then what kicks in are those principles that one has seen in the Charter, and perhaps I can take it because this is the one I've marked up, Authorities Volume 1. And it's quite important that I identify this because this is the point that there is an issue between my friend and myself. This is Authorities Bundle Volume 1, Divider 15, which is a copy of the Charter I was showing you a few moments ago.
Yes. Yeah.
And if one goes to the page, MS page number 740, I've already referred you to Article 20, but if you'd please focus on Article 21.1.
Yes.
This is a freestanding prohibition upon discrimination on grounds of status.
Yes, I see.
And the particular status that we say is the subject of the unlawful discrimination in this case, persons who have a particular immigration status, that's people who are beneficiaries of the Citizens Directive. I don't believe it's in dispute that immigration status is a status for the purposes of both the Charter and the Convention. So the court will be aware that Article 14 of the Convention is the matching provision with Article 21.1.
Yes.
And if you just stay in this document, please, and go to page 742, Article 51, you'll see that this just simply makes the point that one sees spelled out a bit more detail in the Ackerberg case, which is the provisions of this Charter addressed to the institutions and bodies of the Union with due regard for the principle of subsidiarity and to the Member States only when they're implementing Union law. This is an implementation of Union law, which is the making of these regulations. So we are within the four corners of this Charter. So just to step back a moment,
But if that's right, how can it be relevant to discrimination between people who aren't subject to EU law? I mean, this says that the Charter is relevant when you're dealing with matters under EU law. Your case here is that we're discriminating between people subject to EU law and people not subject to EU.
But the principle in Article 20, there's an implementation of EU law, which is the making of the regulations.
Yeah.
That much is common ground. And we say Article 21.1 says that once there's an implementation, this very wide discrimination provision on grounds which includes immigration status applies generally. So to take an extreme example.
Well, anyway, leave it for the moment. I think you'll get on to how you develop it in due course.
But you will also bear in mind, just while I was showing you Article 51, 51.1, you'll also have noticed that at Article 52.1, that any limitation there has to satisfy the test of proportionality. We'll come back to that, but then again, there's an express provision there, including, I emphasise, necessity. So any interference with free movement rights and the right of liberty. Now, just stepping back. So we have three sources of law: common law, equality; general principle of EU law, equality; and Article 21(1). All of those are in play here. And one then can next ask, well, who's the comparator? Or one could ask the question, well, that's not helpful. Let's look at the justification of the difference of treatment between who you say is the comparator, but the Secretary of State doesn't accept, and your client. And as a court, we'll be aware, the question of comparables and justification are often combined. And this is actually a good example of a case where it's useful to combine them. We know that the UK government regarded the statutory comparator until 2009 as being the simple third country national deported under the Schedule 3 1971 Act powers.
Yes.
So the UK government until 2000 had created and adopted a statutory comparator. I've shown you that. They kept referring back to the 1971 Act and saying EU nationals who are going to be deported are going to be treated in the same way as those in respect of whom a decision has been made to deport under the 1971 Act. There was never a power, and there still isn't, and this was accepted before Mr. Justice Eder and in the Court of Appeal, there was never a power to detain a true third country national prior to a decision to deport.
Yes.
Yet there we see a radical move from that. Now, we essentially have two arguments. First of all, there was a clear statutory comparator. And secondly, if the government doesn't accept that, what's the difference? If the government says, well, there's actually a difference between an EU national who may be deported and a third country national who cannot be detained prior to a decision as to whether or not to deport, what's the difference between them? And our first answer is that this very much reflects the position in the Belmarsh case, which is in terms of, for example, propensity to abscond, propensity to commit further crimes, which one might think were indicators of why you make your mind up, decide you want to detain them, although the propensity to commit further crimes is a difficult one, but just for the purposes of argument. What's the difference? What's the difference between an American national who's in exactly the same position as my client and my client? That American national remains free while the Secretary of State makes her mind up.
Yes.
Whereas my client is detained. Now, how did Mr. Justice Eder and the Court of Appeal deal with this problem? Because they accepted our argument to a certain extent, which is they accepted that there was an apparent difference in treatment, and they dealt with it in what we've called, or I call now, a net accounting approach. And I need to explain what that means. What they said, and which we say it turns discrimination law completely on its head, was to say that because EU nationals have lots of other great rights, rights of free movement and residence, greater protections in many ways, one can net off the apparently detrimental treatment they suffer as regards detention, as against those other very, very positive rights they enjoy. That's why I call it a net accounting approach. Another way of looking at it is a kind of package holiday approach, which is
because people get up and give women their seats on the tube, they are not entitled to be treated equally in job applications.
Absolutely.
That's a very bad sort of example, but it's what you're saying, isn't it?
Absolutely. And with respect to in particular Lord Justice Moore-Bick, one can't criticise him overly for going down that road, because there is some very kind of clear case law, which wasn't cited below, which makes it clear that you can't take that approach, which is when it comes to discrimination, justifying discrimination, particularly discrimination on a suspect ground, a prima facie suspect ground, such as immigration status, what you can't do is effectively do this overall net accounting. And given the time, perhaps I can identify in our.
Before we come to that, in essence, the respondent's answer to your argument is this, isn't it? They say, look, there's absolutely nothing in EU law which touches on comparison between treatment of EU citizens and non-EU citizens. So that whole area of argument is simply irrelevant. Looking at it in terms of domestic law and whether there is a rational justification for the regulation, they say that if you actually drill down, your client is no worse off at all than had he not had the benefit of the EU directive and the regulations. Actually, he'd have been a great deal worse off in all probability. He'd have been deported long ago. And if you're looking at whether there is a basis properly sustainable in domestic law for showing that something irrational in the power now taken to deport him, you fail there. It seems to me that those are really the twin points you have to meet.
Sorry.
The moment you're sort of straddling them together.
Perhaps I can deal first of all with the common law point. First of all, I do not accept that my client would have been deported long ago. We are where we are now, and we're looking at this legislation, not the particular. The legislation applies across the board. The legislation applies across the board, and at common law, irrespective of the EU context, there is a radical difference in treatment in relation to detention. And it has never been acceptable at common law, certainly on any principle of discrimination I'm aware of in English law, to say that a measure can be defended as being rational because in some other aspect of the decision-making process concerning an individual, he gets some other benefit.
But I mean, sorry, have I heard you correctly? Are you saying that if he had not had the benefit of the regulation, if he had not married a French citizen or become a partner of a French citizen, whatever it was, it's incorrect to say that with his track record of convictions, he'd have been deported.
Absolutely, my lord. And I say that because my client had an asylum application which was not pursued, given that he obtained another basis for remaining. So I don't accept that as a proposition, my lord, that he would have been deported. And in a sense, that's, with respect to a slight diversion here, because what we're focusing on is what's the rational basis, first as a matter of common law, and then under the EU law for the difference in treatment.
Would you say what we're focusing on? It occurs to me that what you're focusing on and what the respondent is focusing on is not exactly the same matter.
That may well be right. And that's why the respondent seeks to circle around our arguments by saying, well, even if you can kind of point at a problem, there's no need to just strike down this legislation.
Well, he's saying you can't just pick out one bit of a complicated statutory scheme and say, because in this isolated respect, you're worse off than X would be, therefore this is an irrational and unfair and discriminatory scheme.
But I say that my lord has identified the position of Mr. Ward, as I understand it. We say that's just simply wrong. I can do that because what the common law requires is Mr. Ward to say there is some rational reason connected, for example, to propensity to abscond, propensity to offend, and that there is and that the characteristics of the people that benefit from the preferential rights, the American national, the characteristics of that person as regards the propensity to do those acts is fundamentally different to someone under the EA regulations. And we come back to this point. I keep coming back to the Belmarsh case, but it's quite important to bear in mind the reasoning in that case. That obviously was a case decided on the convention.
I don't think he's saying that Moroccans are more likely to offend than Americans, or French are more likely to offend than... that's not part of his argument at all.
Well, I think that my friend says, and my lord has put it this way, which is that my client benefits from other benefits in the regime of immigration control because he's an EA national. And then that effectively can justify the difference in treatment when it comes to deportation. And I don't accept as a matter of common law rationality that is right.
The difference between you in principle is that they're adopting a panoramic approach to the entire regulatory system which affects your client. You say that's not permissible. You've got to drill down and concentrate only on the point which you say gives rise to the discrimination.
Absolutely. And we have strong support, my lord, for that, because that's exactly what Lord Bingham did in the Belmarsh case, which is he said, when it comes to liberty, there's an exacting standard to be applied. And it's not an answer to detaining some people and not others to refer generally to their immigration status. That's exactly what happened in that case. And that's why I made the point at the outset, which is that although the background of this case is EU law and convention law, the common law has already reached that position. That was the point made by Lord Bingham. It's also made by Lord Sumption in the Bank Mellat case, which is that we don't really need to resort to these principles of EU law or convention law because the government has to show a rational distinction. A rational distinction is not made in our submission by what one calls the package of benefits approach. And I was just going to show you that's the position we say as a matter of principle at common law. But in our supplementary note, if I could draw your attention, please, to page 8, paragraph 26. This is a supplementary note accompanying the supplemental authorities.
Right.
And it's
Page 8.
Page 8.
Yes. Yep.
And just dealing then with the two particular cases that we identify, which were again very familiar to the court. The first is the Barber case at 28, which concerns equal pay, where the court said you had to focus on the particular aspect of remuneration rather than, again, an overall package. But more striking in terms of its relevance is the Roma case, which is over the page at 9, which is a case about differential treatment between registered life partners and married people. It's a German case. And in that case, the court said it was not appropriate to look generally at the position of married people as compared generally to the position of registered life partners. You've got to look at the particular benefit in question and see, is there a reason for a difference in the particular benefit in question? That was a case concerning differential pension provision. But none of this, in a sense, my lords, is new. This is no more than, in substance, the principle being applied by Lord Bingham in Belmarsh. What's the difference?
At that point.
While I'm in this note, can I also take you back, please, to paragraph 4, page 2.
Paragraph 4, page 2 of this note.
Yes, that's right.
Yes, 6 points, yep. Yep.
And okay. In fact, if I can go over the page to paragraph 9, first of all, please. This is because it deals directly with my Lord Carnwath's point.
Yes.
And the answer there is set out that Article 21.1, which I've shown you, which is the status-based discrimination provision, is engaged immediately. EU law is being implemented. And the court will have noticed that the case relied upon, the case of Vatsuris that's relied upon, is not a case concerning Article 21.1, It's a case concerning Article 18. We're not aware of any case which would support the proposition that if Article 21.1 is engaged, in other words, once the jurisdictional test is satisfied, see paragraph 15 and 16 of our note. In other words, once Article 21.1 is engaged because you are implementing EU law, that somehow Article 21.1 doesn't cover status-based discrimination. Now, that's not a horror scenario, because the point we make in Article 18 is that even if you get through the front door and show that there is some prima facie discrimination, it's always open to the state to say, actually, I can justify this. So if Mr. Ward wants to justify treating an American national differently to an EU national, he would have to have explained with evidence why in 2009 a different approach was taken, and put some evidence in, which we know he wouldn't do because it would make no sense, showing that for some reason people who are being considered for deportation as an EA national are more likely to offend or abscond than others. He hasn't done that. That's one line of argument, which is Mr. Ward says that Article...
Your case is that all these categories have to be treated the same. Does that include the home state national?
No, well, in terms of more preferential treatment, well, that would be barred under nationality discrimination, under 21.2, so we wouldn't have that. If there was more beneficial treatment being given to a home national, that wouldn't be a problem. But can I just stay in my note, please, and take you to paragraph 20? And it's quite important that I address what Mr. Ward says is a threshold answer to the entirety of the discrimination claim, which is he relies upon a case from the European Court of Human Rights called Mustakim and some further cases.
Yes.
And in those cases, I can summarise it because there's a common feature of all of that line of cases. It's a case where a non-EU national is being deported, and in Mustakim's case, it's Belgium. He's a Moroccan national being deported from Belgium.
Right.
And he says, you can't deport me, it's unfair, because I'm being deported when, although I've committed these crimes, an EU national couldn't be deported from Belgium, or it would be much harder to do that.
Yep.
And the court answered that submission by saying that was an objective justification, which is that effectively by treaty, Belgium has agreed to give greater rights to EU nationals than it has to others. Fine. Well, it doesn't apply here, because here we have...
Oh, here's the other way around.
Other way around. But more fundamentally, this is the very case which the Attorney General relied upon in the Belmarsh case before the Court of Appeal successfully to persuade the Court of Appeal that it was fine to detain foreign nationals, because Mustakim says you can always treat your own nationals or others in a different category more preferably, in a more favourable way. And Lord Bingham rejected that, as did other members of the court. We provided the citations at paragraph 22, which is, then they made the point, which is a conclusive answer to the point as it's made by Mr. Ward today, which is that it's true. You can, when it comes to deportation, removal, you obviously will treat your own nationals differently to nationals of another state. That's obvious.
Well, you can't deport your own nationals.
Absolutely, absolutely. But
You may be able to extradite them, but you can't deport them.
But what the point made by Lord Bingham, with which the other members of the court agreed, was that, well, that's all very well when it comes to removal, but it doesn't provide a justification when it comes to detention.
Right, understand.
So that's why Mustakim doesn't really help here.
Can we just look at the clearest bit in Lord Bingham or one of the others on that?
Certainly. If I can, it's in Authorities, Volume 3, Tab 40.
The paragraph 56 on page 1357.
That's right, my lord.
Yep.
That's where Mustakim is first referred to.
He says, but that refers to immigration.
Indeed.
And
Not
Yep.
liberty and detention.
And then according to your note, he turns to that to paragraph 67,
That's
On
the
page
conclusion.
1365, yeah.
Yes. And it's essentially E to F of paragraph 68 at page 124. And there he observes, what has to be justified is not the measure in issue, but the difference in treatment between one person or group and another. What cannot be justified here is the decision to detain one group of suspected international terrorists, defined by nationality or immigration status, and not another.
My lady held the paragraph 229 by effectively saying that they have, so long as they're here, they have the same human rights as everyone else.
Absolutely.
That's the point, really.
Absolutely.
Yeah.
And then there's actually an even clearer statement. If I can just ask the court to
Couldn't be, yeah.
bear with me and go to Lord Hope's speech at page, in the report it's 142, in the PDF it's MS page number 1383, paragraph 134.
Yeah.
There the position is dealt with head on. Paragraph 134 under discrimination.
That's where he deals with Mustaqim.
Yes, and he says in the first paragraph, I said earlier that I would regard it as a serious error to regard the right to control immigration as decisive of the discrimination issue in this case. So just to end that point, we submit that Mustaqim is an answer when it comes to differential treatment in expulsion, for obvious reasons, but it's not an answer when it comes to differential treatment in detention decisions.
Understood. Yep.
Okay. The court may already have this point as well, which is that there is no, unlike the Mustaqim case, there is no legal order or special legal regime which required in international law the preferential treatment of non-EU nationals. So in this case, the American comparator I've been giving you, there's no international obligation that the Secretary of State says she is under, which requires her not to detain third country nationals, and which explains and justifies her treatment of those persons. I'm going to stop there now in relation.
Lord Sumption says the same, you say, in Milat.
Yes, in fact, we've set it out some length. If you would, I've set it out in our case, so I won't need to take you to the, it's a very long footnote, which I will just try and identify. It's at page 33, paragraph 78. And it's footnote 71.
Yep.
That's talked about. Well, it's talked about both in terms of proportionality and discrimination. I would just emphasise one thing. I'm grateful for my Lord for identifying that, which is the point I wanted to make, which is that when one looks at this through common law spectacles,
Yep.
Lord Sumption's approach in the Bank Mellat case was to talk about this as irrationality. So in the footnote citation that we've got at 71, it says, a measure may respond to a real problem, but nevertheless be irrational or disproportionate. So again, through common law eyes, he regards what I call the broad principle of equality discrimination as being an aspect of irrationality.
Can you give me a page reference for that?
96.
MS 96.
Yeah, well, that goes back to Lord Hoffman, doesn't it?
In Matadine,
Yeah.
that's right.
Well, that was why he was deciding that the discrimination in question didn't take place.
Yes, absolutely.
I always find it ironic that Matadine is cited for this great proposition, which he promptly went on to say didn't apply.
Sorry, Melody, in our written case, it's MS page number 96. Bottom of the page is the lengthy citation from Lord
All right,
Sumption.
yes, thank you.
So what are you getting out of that?
There,
I mean, other than
that's a case where 3 points are rolled up as a basis for finding the legislation unlawful. One is disproportionate, secondly discriminatory, and it's also irrational.
But he's saying and or. I mean,
Well-
certainly I agreed with this judgment, but I
Yes.
don't see it as giving sort of carte blanche to all those three as sort of independent principles.
Well, I only pick it up because he used the word irrationality, irrational,
Or proportionality.
or disproportionate.
Easy.
I'm going to turn now to the question of proportionality, but just to summarise in relation to discrimination, common law, general principle of EU law, or Article 21(1), the burden is upon the Secretary of State to justify the discrimination, and there's no evidence to justify that. In particular, if one were looking at evidence, one would have said in 2009 there was some pressing social problem.
Well, wait a minute. You say, we don't need to go into all this. You say if you establish discrimination, then you're home and dry because there's no self-evident reason and no proffered reason to justify it.
That's right.
End of story.
That's
yes?
right. I only make the point because at a particular part in Mr. Ward's case, he asserts that there must have been a problem in 2009. That's why they changed things. But we'll ask, well, where's the evidence of that?
Yes, I see.
That there was a problem that meant that there had to be a fundamental change. In particular, there was a fundamental shift from a particular statutory comparator, which was regarded as being fine, from 1973 to 2009, and then a different...
I can see how you can say that it's not enough to justify, to say there must be a justification, otherwise we wouldn't have done it. Otherwise, that would make justification rather an easy hurdle to cross.
We only do the right thing.
Omnia Rita, prism winter, I say what.
Okay. Ms. Dubinsky reminds me, but I won't take you to it in our note, which is that Article 18 of the treaty, which concerns discrimination on nationality grounds, we do have a point that there's discrimination there as well.
Yeah.
I'm getting rather sort of confused. I mean, you've got a very simple point, which is they brought in this new power to detain without having made a decision to deport. And this applies peculiarly to EEA citizens. And you say that's discriminatory.
Yes.
Well, that I can understand. You then sort of throw in everything from the EU principles of discrimination, common law, now the Charter. Which is your best one? I mean, I can't believe you need them all. Which is the strongest one? Because otherwise we find ourselves going round and round in circles.
It's the general principle of equality under EU law.
Yeah, well, that's what I would have thought. So
Absolutely.
Let's stick with that.
Absolutely, but
See where we're going.
Then we can decide whether it's necessary to refer that question.
Well, that's the point.
But I must emphasise that that it would be surprising if the general principle of equality under EU law was more exacting than the common law. I just don't see that.
Why?
In this particular case...
And why does it matter? I mean,
Well, in a sense, it doesn't matter. I don't want a reference, that's why. We want to win the case here and now, and the common law has
You put
the right...
you put it first on common law.
Yes.
You fail on common law, then you put it on EU law. Okay. I think we had that. Yeah, of that.
Okay. Sorry, before I was going to get to proportionality, I don't want the court to lose sight of the Article 18 argument, which is that there is a nationality discrimination here as well.
You mentioned that, yeah.
On a very simple basis, and it is not a basis which one can dismiss as hypothetical, because this type of argument has succeeded before the European Court, which is that my client, who married a French national in the UK,
Yes.
is in a worse position than, for example, a British national who would have married an Algerian individual. So the position of the wife or partner is a factor that one has to consider. And Mr. Ward poo-poos that and says, well, that's completely hypothetical. What gives you the right to complain about that? The wife's not here. But yet that's exactly what happened in the Surinder Singh case, which is before the court, where Mr. Singh married a...
Well, where is it? Where is it?
It's in our supplemental authorities.
Thank you.
And it's set out in our note on supplemental authorities at paragraph 8.
Okay.
And I can probably do with that because we've set out the relevant part of the judgment of the ECJ. It was a case that caused some surprise at the time, but it's well-established EU law now. It's page 3, paragraph 8 of the supplementary note on authorities.
Right.
So Mr. Singh, Indian national, marries a British national.
Yep.
Mr. Singh and his wife go and live in Germany, where his wife is exercising her free movement rights.
Right.
They get divorced, and he wants to come back to the UK, and the UK government says, no, you're not coming back, you're not married to an EU national anymore. So he brings a judicial review, not her. She is long gone. He brings a judicial review and succeeds ultimately in the European Court on the basis that what may seem like a hypothetical is still an infringement of treaty rights, which is that someone might be deterred from moving if they thought that following a divorce their partner could not come back to live in the country that they'd originally made their home. So this type of hypothetical is well established, and the hypothetical we've set out at paragraph 8.
Yes, thank you.
Okay, so if I can then move on to proportionality, and I'm happy to say that I believe that other than the test of proportionality, which is a matter of major dispute, I don't believe that there is a dispute between my learned friend and myself as to the application, as the application of a proportionality test in principle. So if I can take you straight to our case, to paragraph 65, please.
Thank you.
And it's MS page number 86. We've set out there, and I believe, my friend will, when he responds, tell me if this isn't common ground, I believe that the principles we set out at paragraph 65, and the four sources of the argument that proportionality will apply, that is a correct summary of why Regulation 24 needs to be justified according to the test of proportionality. And that appears not only as a matter of general principle, but also on the basis of the express wording of the Citizens' Directive, Article 27, which we looked at briefly earlier this morning, which requires any public policy measures that are taken to be justifiable on principle of proportionality. But going to the jurisprudence of this court, this is at page 66, sorry. Page 25 of our written case, where we refer at D in the middle of the page to the Lumsden case. It's now well established.
Page?
It's at page 25 of our written case, MS page number 88. Middle of the page, you'll see a subparagraph D.
Yes.
National measures falling within EU law must satisfy a proportionality test. That's the Lumsden case.
Yes.
Now, so I believe that is all common ground. Where the real dispute arises, as I understand it, is the application of a necessity test. So if you'd stay in our case, please, and to go to paragraph 67, we say the start and the end of the debate on this principle is the Lumsden case. Very recent decision of this court, where the test of necessity was set out. And it's very familiar, which is the two questions, 68A of our case, page 26. First, whether the measure in question is suitable or appropriate to achieve the objective pursued, and secondly, whether the measure is necessary to achieve that objective, or whether it could be attained by a less onerous method. And then we follow that, Lord, between B and G, going over a number of pages, making it clear in our submission that there is only one necessity test being applied here. There's no other necessity test. There's no lesser test that the government needs to satisfy. And indeed, one could say the high point of the position in recent years is the Digital Rights Ireland case, which is at letter F at page 27. Now, there's a very important point I want to make here, which is going to straddle with the legal certainty point, which concerns what's called the Return Directive, which is at G at page 28. That's by way of background. The EU has legislated on the question of the conditions and circumstances of the return of third country nationals from within the EU to other countries. Obviously, that doesn't apply to EEA nationals. So people who've got no EU law rights at all, they are the subject of some legislation. But that legislation, which is known as the Returns Directive, which I'm going to show you, does set out some minimum standards that have to be applied by the member states.
And this is relevant because?
It's relevant for, first of all, I should make it clear that the UK has opted out of this directive,
Yes.
but it identifies minimum standards, which we say are the minimum standards which this court should find exist in any event. And there are two particular points which are at G2 in our written case. First of all, and it may be useful just to have this open, it's in the core volume, sorry, it's in the Bundle of Authorities, Volume 1, at tab 18. And I'm showing you this for two reasons. First, when it comes to detention pending deportation of these third country nationals, detention is a very, very last resort. And if you'd please go to Article 15.
Yes.
And it's Article 15.1. These are the circumstances in which member states are authorised, it's MS page number 719, authorised to detain true third country nationals. First of all, in 15.1, when no less coercive measures are available.
But what is this going to? I mean,
Well,
the furthest it goes, surely, is to say that we should, if it comes to this, the right to detain that we're considering in this case, it should only be exercised when these conditions are satisfied.
That's right.
EU law, but does it go any further than
Okay,
that?
but there's a second point as well, which appears in, that's quite right, my Lord, which appears in Article 15.5, which is a mandatory time limit, and you will notice that part of our proportionality challenge
Yes.
and the legal certainty challenge concerns the absence of time limits on detention. So, if I can put it this way, what Article 15 does is it creates a form of Hardeal Singh process, which is you're only going to detain for a short period when necessary. But unlike Hardeal Singh and unlike domestic law, it imposes a hard time limit.
Yeah, but it doesn't mean it's mandatory.
Well, there it is mandatory.
I mean, we've opted out of this, I thought.
We have, but I think the point is that in the scheme of things, these individuals have the lowest category of rights of free movement and protection from expulsion within the EU.
Yes.
It is people who have no rights at all. We're in the rather odd position in this case, where we've got EU nationals who are going to, the net position of the EU nationals is much worse than this category of person.
But as long as it's applied proportionately and in accordance with Hardeal Singh standards, then the problem doesn't arise.
Well, I'm going to come back to the issue of whether or not Hardeal Singh is enough. I'm not at one moment saying Hardeal Singh isn't necessary, but I'm going to be submitting in due course.
You're not saying that your client, there was any breach of Hardeal Singh principles in your case?
No, but we are saying that in terms of legal certainty, when we come to it, Hardeal Singh isn't enough. It's necessary but not sufficient. But I'm slightly going out of order.
What is the provision under our law? There's no specific time limit, is that right?
No.
But there is a sort of implicit, is it,
Well,
a reasonable time? Or?
We'll come to look at the cases in relation to that. There is, one could say that people thought that there was an implicit time limit, but we'll look at what's happened in the case law in relation to Hardeal Singh. But there is no express time limit in legislation. But
there's often no express time limit.
well,
So that's why the court introduces notions.
absolutely,
like,
but one
such
does
as
ask the question.
A reasonable time in all the circumstances.
Okay, one does ask the question, though. This is the only area of law that we're aware of where someone can be detained with no mandatory time limit. So in criminal law, in mental health law, there is always a hard time limit. But I'm going slightly out of order. Let me just finish on, if I may, just finish on proportionality. The proportionality arguments, we say, if one applies a necessity test, one asks, how can it have been necessary, this is the overlap with discrimination, how can the government show that it was necessary under a proportionality test? And here we're in our case at page 31, paragraph 73. How can it show it was necessary? And in the PDF version, it's MS page number 94.
Yep.
All of the points that were made on discrimination apply with equal force here, which is that the government can't show it was necessary
I understand.
on a proportionality test because they didn't do it for the others, and they didn't need it.
Comes
same
back
way.
to A, yep. Okay.
Absolutely.
Okay,
Absolutely.
I understand, yep.
Absolutely. So there has to be some objective justification, and none has been forthcoming. And the court will be aware, see paragraph 78 of our case, referring to the Belmarsh case,
Yes.
that the Belmarsh case was decided on the basis of proportionality, but also discrimination. Similarly, the Bank Mellat case
Yeah.
decided on proportionality and discrimination. So we submit that there is a burden of justification here upon the state which it has not met. Now, the burden we submit is even greater than it might have been, because we know that up to 2009 there was an extra right of free movement because one was not going to be detained pending a decision. But we also know that the purpose of the Citizens Directive is to enhance rights of free movement. That appears repeatedly as the theme in the recitals.
Yes.
Now, it might be said, well, there's a reason for detention in these cases, and we deal with this in paragraph 74C of our case, which is that, well, the Secretary of State needs to be able to make her mind up as to whether or not she wants to deport someone who's an EEA national, and there might be circumstances where she needs to detain them while she makes her mind up. Now, two answers to that. First of all, why is there no need to detain an American? Because an American also has the right to make representations as to why he should not be deported. Secondly, so there's no material distinction there. Secondly, there is the point that the existence of a power to detain before you've made your mind up, and this is generally going to be applied to people who are in custody and about to be released, it effectively excuses administrative inefficiency. So in my client's case, there's no reason why the Secretary of State couldn't have, while my client was in detention and prior to his release from his sentence, have conducted the process of receiving his representations. So there's no real reason why there needs to be this extra bridging power, one might call it, a bridging period of time between an actual deportation decision and a consideration of whether or not deportation should be undertaken. And you already had the point that if there were any such reason, it would apply equally to the American national.
Yeah.
So if I can end on this particular issue by saying that we know that there is a less intrusive measure available, which is detention following a deportation decision. We know, and no one has suggested the contrary, that serves all of the public policy aims of the government. There's no good reason why that less restrictive measure could not be used here. Okay, and it's worked for nearly 40 years prior to 2009.
What's for the test for detention following the order?
Hardiel Singh.
But is that a test of necessity or reason?
Well, we'll look at that. It's a test. We'll look at the particular provisions of Hardiel Singh. It is a form of. It's a much harder test than just reasonableness. It's more exacting than that. So the Hardiel Singh principles are tough, but I'm going to explain why.
So what is the test in a sentence? Is
Well,
it reasonableness or necessity?
well-
Something in between, and what is it? Just in a sentence.
Basically, first of all, the Secretary of State can only detain or start to detain someone with a view to deportation, not for any other purpose.
Yeah.
And then while deportation remains in prospect, or reasonably likely she can detain, but the moment that deportation is no longer likely because it may
I
not...
understand that, but I'm asking about the test after the order is made for detention.
For continuing detention?
Yes.
The
Or indeed new detention.
I'm sorry?
Or new detention.
Well, the test, once you're deciding to... you can only detain with a view to deportation.
Yep.
That's it, basically.
I understand that.
Yeah.
But is it sufficient to say with a view to, without some kind of test of reasonableness or necessity for the detention in that period?
We say there's a matter of EU law that it needs to be reflecting what I've shown you in these provisions on the returns directive, the last resort. In other words, less coercive measures are not available. That's our case. Yeah. So the Secretary of State can't detain just because she thinks she wants to deport someone. She's got to also be satisfied that there is no other alternative, detention being the least coercive. Sorry, no less coercive measure available. That's what we say the test is.
And you say because it's difficult to know quite why this rule was introduced, little difficult to know.
We don't know.
Yeah.
We don't know.
Understood.
Okay.
Okay.
If I can move on then to again, separate freestanding challenge, which is legal certainty. And again, I'm going to say that the common law and EU law and convention law all march hand in hand in this area. And I should explain what I mean by
So we're now into what's in paragraph 89 and onwards, are we, of your submission, page 102 of the MS, page 39 of your...
That's where we are.
Thank you.
But if I can just stay in...
This assumes you've lost so far, does it?
Absolutely. But it's important as well for another reason. It's important for another reason, my lord, which is there are two kinds of detention at issue here. There's the detention prior to the decision.
Yes.
To deport under 24.1.
Yes.
And the court will have realised that there's also detention under 24.3, which is the period after a decision to deport. And we say that subsequent detention under 24.3 is also unlawful. And the principal argument in respect of that, the unlawful nature of that detention, is that it violates the principle of legal certainty.
So does legal certainty apply to both?
That's right, yeah.
But your previous arguments don't apply to 24.3.
That's right.
Okay, thank you.
Well,
Your legal,
I can just check.
am I right in understanding your legal certainty point relates to the absence of a defined temporal limit?
Yes.
It's nothing wider than that, that's it.
Essentially, that's it,
Yeah.
yes. Okay. And the point is essentially this.
So that's the 6-month point in subparagraph 5.
Correct. So the background is that as under general EU law and the Returns Directive, although there are principles setting out the circumstances in which one can detain and how long one can detain for, there is a hard time limit. And there is no hard time limit in UK law.
Yes, I see.
As regards detention. And we've looked at the power in Section 24.1. It applies also to the power in the 1971 Act. There's no specified limit as to time. And both at common law and under EU law, we say that there is a principle of legal certainty. It's easier to find the principle more clearly stated in EU law and ECHR law, but it's not that different when one looks at recent statements of this court in relation to the general English legal position.
So this is a departure from Hardiel Singh as approved in this court.
Absolutely, no, not at all, not at all. It is, Hardiel Singh is necessary, absolutely, because Hardiel Singh sets out why you can detain somebody.
Yes, but there's never been suggested as a fixed time limit.
Absolutely. But what I'm going to show, my lord, is that Hardiel Singh is necessary, but it's not sufficient. And in particular...
You say this is an addition to Hardiel Singh.
Indeed, it's an add-on. It's necessary, but not sufficient. And I'm going to explain why. And this is not something we're just making up, because the position of the government itself and the history of the cases on Hardiel Singh, only a few of which we need to look at, shows that Hardiel Singh is not able to deal with the problem of time limits.
I understand.
So the principle of legal certainty, if you could go in our case, please, to page 41, paragraphs 93 and 94.
Well, is there a reason why the logic of your argument doesn't apply to all cases in which a detention order has been made following a decision, following a deportation order or a decision to deport? because that power has no time limit built into it. The courts have developed it under the Hardy-Singh legislation. Now, if you say Hardy-Singh is necessary but not sufficient in the present instance, why doesn't the same apply in every case?
Well, logically it does.
Right, correct.
But here we have the added argument, which is that we have EU law principles, and that if and insofar as this court finds that the absence of a time limit violates the EU law principle of legal certainty, which we'll see is a very strong one, exemplified by the digital rights case, then the court can say, although the issue of the general powers is not before this court at the moment, we're just considering the position of an EU national.
Yeah,
but my Lord's point is absolutely right.
Yeah, so the implications of your argument being accepted on this point would indeed be very far-reaching.
Well, potentially, but the court, proceeding in staggered stages, could say and would say that here we're dealing with an EU law context. And in an EU law context, where one has heightened rights of protection for EU nationals, we do not consider a power which allows detention with no limit as to time is justifiable.
But you introduced this section of your argument by saying that common law, EU law, and ECHR law march in step on the issue of legal certainty.
Well,
so you're putting your position first, it may not be first in terms of the strength you attach to it, but first in the list you've given to us.
Okay.
Common law. As far as the common law principle is concerned, it wouldn't matter whether they're an EU citizen, somebody who's related to an EU citizen in such a way as to have the benefit of the regulation, or somebody who has no connection with the EU.
That's absolutely right, my Lord.
And that is why the implications of this part of your argument would be profound.
Okay, except there's one other added ingredient, which I mentioned at the outset, which is we're not just dealing with liberty, we're also dealing with free movement rights. And that when one has an interference with free movement rights, which are a pure EU law creation, then one could have the court saying that in those cases where free movement rights are implicated, and therefore EU law is involved, there's a differing standard.
Of legal certainty.
Absolutely.
So this is your legal certainty argument is where it splits off into a number of different subsets. There's legal certainty in relation to power to detain, legal certainty in relation to liberty, legal certainty in relation to freedom of movement, and each itself sub-splits according to, or possibly, the common law approach, the EU approach, and the Strasbourg approach.
That's right.
Right.
But I emphasise the
It doesn't sound much of a recipe for certainty.
Well, I emphasise the fact that one can't lose sight of the fact that there's a free movement issue in this case, which is why I said at the outset that's one of the themes of this case, which is that although I'm not inviting the court to do this, if the court were...
Is free movement within the United Kingdom, is it, or free movement between the states?
Well, basically, while he is within the United Kingdom and within the EU, he's entitled to free movement rights. So any restriction of his liberty, even while in the United Kingdom, is an interference with his free movement rights.
No, sorry,
I'm
was
sorry.
me interrupting
Yeah.
you, and you were about to
Okay.
tell us what the propositions are.
The important point I just need to underline in relation to my Lord's point is I'm hesitant to say ever that common law is less exacting than EU law. But when it comes to free movement, if free movement rights give us a stronger right, then they will necessarily differ from common law. So the court may conclude, although we wouldn't invite the court to do this, that there is no problem at all with at common law with no limit as to time, and that Hardy-Singh is enough. We would say, well, if that's the current state of the common law, which we don't accept, if that's the current state of the common law, then that's certainly not the position under EU law, where more exacting standards are required in respect of as regards legal certainty. But can I just take you back to our case, and I can, dealing with it in stages as to where do we find the relevant principles. First, just dealing very, very broadly with the question of common law, if I could ask you please to go to page 41 of our written case.
That's internal numbering.
That's internal numbering, MS page number 104.
Thank you. Yes.
And we've set out 93, 94 and 95 from three relatively recent decisions, certainly Beghal and...
I think I'd be a little careful with Beghal because Lord Hodge agreed with Lord Hughes, but although Lord Dyson and I agreed with the result, we expressed ourselves slightly differently, and Lord Kerr dissented.
Okay, well, perhaps I can leave it at this. I would say the common law principle of, and it's an aspect of the principle of legality, is that members of the public must be governed by clear and publicly accessible rules of law.
It's got it pretty clear from Lord Bingham.
Yes.
Can't do better than Bingham.
And obviously not every rule can set out every circumstance, but one sees a common feature of these cases, which is that obviously the law itself might not be on its face absolutely clear, but with the benefit of legal advice, you'll see that phrase that appears in quite a lot of the convention cases, with the benefit of legal advice, can you essentially know what the law is? The key issue being one of foreseeability.
We're looking for a case which says there's got to be a time limit.
Well, that's what I'm going to come to.
Yeah. Well,
So that's broadly the common law position. If one goes back to our case to the start, to 89 and 92, 89 to 92, all we have at the moment as regards the power to detain under these EEA regulations, see paragraph 89 of our case, is a statutory, not even a statutory, a policy, an executive policy of 15 days, which can be changed whenever the Secretary of State considers it's appropriate. There's no hard limit in any legislation.
Yes.
And what's important, as I've said, is that one needs to be able to foresee the consequences and to be able to predict.
And you rely on what's in paragraph 103 to support the proposition
Absolutely.
that the mere statement of policy is not enough.
Indeed.
I mean,
Now,
the real difficulty, though, is a practical one. I mean, I see from the footnotes, 85, your footnote 85, concerns expressed in the Court of Appeal at the difficulty
Yes.
pinning down what may be a time. I suspect that really comes from the way the world is. I mean, if a decision is made to remove and return somebody to a country affected by internal strife, it can be very difficult for the Foreign Office to know just when they're going to be able to charter a plane to return the person to X land.
indeed.
And the wisest Foreign Office official can do often no more than say that we really do believe there's a realistic prospect of this happening within the next 3 months, and we want to keep the person inside because once we let him out, we've lost it. But we're not in control then, we don't know. That's the practical problem in a time limit. You could, I suppose, have a system where you said the maximum period for any one period of detention is 3 months, but the Secretary of State may renew that period if she considers there's a reasonable prospect of doing so within the next 3 months. And so you have a rolling system where you'd have fixed time limits. But query, what benefit would actually be achieved for the person who's sitting in detention by introducing something which would be a nominal time limit?
Well, it's not for us to prescribe what the position should be, but my Lord, the answer to my Lord's point is that this very issue arises across the EU. We see in the Returns Directive a form of hard yielding process, but with a hard time limit. So the EU is aware that there may be practical difficulties. But in order to meet the requirement of legal certainty, it imposes a hard time limit on detention. Because, bear in mind, these people have not been convicted of anything. Often they may not be returnable for no reason, for reasons nothing to do with them. And I know members of this court will know from administrative court cases, often people can't be returned to places because it's simply not safe.
Right.
So, but we say the requirement of legal certainty does require, in liberty cases, a hard time limit. And
Where you keep on saying that, like you keep on promising us to show us a case which
okay,
says
I'm going to show you, I'm going to go right there now. If you could, please can go to page 44 of our case, paragraphs 102 and 103. 102 is the principle that conditions for deprivation of liberty be clearly defined in order to meet the requirement of lawfulness. But then there are a series of cases
Yes.
where the European Court of Human Rights has said, in the context of all of these countries, starting with the case of Mathloom, which is the first one, which we might want to turn up, which is at authorities tab 165. I'll just Volume 14.
The official versions in French we've supplied translation.
Okay. And it's at
Tab.
165.
And as you take us to these, are you going to reply to the riposte of the respondent? Because from paragraph 258 onwards in the respondent's printed case, he's set out his comments. You may want to knock them down.
Absolutely. So I think that the point being made by my friend is that these cases do not stand for the proposition that the absence of a maximum duration specified made the detention, exercise of detention power unlawful. And the case originally supplied in French, but we've got a
You've got translation on
translation
4869.
starting at MS page
4869.
4869.
Yep.
And if I can take you to the decisive paragraphs, it's at MS page number 4885. And this is a case where the individual was detained in Greece, pending deportation, for almost 2 years. And that may sound like a startling period, but the court will know from the domestic law cases that's actually not that long. There are many cases, unfortunately, where people are in administrative detention in the United Kingdom for periods of time.
Well,
near to
Jahal was there for a very, very long time, wasn't he?
Absolutely. And at 33, the court says, in light of the court concludes that the relevant provisions of the domestic law on detention of persons subject to judicial expulsion do not set the maximum duration of detention and do not meet the requirement of foreseeability. Now, that's not the only case, because that very point has been made repeatedly.
But is a maximum detention an unvariable maximum?
Well, it should be. There should be a statutory or legislative limit as to how long detention can go for.
So what's the answer to my question? Could the legislation set out a series of limits depending upon the circumstances?
Well, no. In my submission, it should follow at the very minimum what one sees in the Returns Directive, which is that after.
Where is the Returns Directive?
It's in tab 20 of our Authorities Bundle, Volume 1. I'm so sorry.
18.
Sorry, tab 18.
Yep.
Perhaps I can just.
Yeah, we looked at this a second ago very briefly.
And it's Article 15(5) at page MS number 790. And 6. There's a further possibility for an extension.
Yeah.
Okay. Mr. Dubinsky reminds me that one can see the analogue of the Hardy-Singh principles in Article 15 15.1 and Article 15.4, but supplemented by a hard time limit.
So that's 6 months with a possible 12-month extension.
Yes.
Is that a convenient moment, Ms.
Yes, my lord.
Saini? Thank you very much. We'll resume again at 2 o'clock. The court's now adjourned.